Brett Hudson.
Thank you, Mr. Speaker. It's a pleasure to rise in support of this Evidence Amendment Bill in its first reading. I'm sure we'll be canvassing some points that other members have raised here, but it is important, I think, the changes that are promoted or proposed in this bill are extremely important and very, very welcome. Very welcome, it seems, in this House, and I'm sure, Mr. Speaker, very welcome across New Zealand. Particularly as I think relates to matters around the means of providing evidence for children and also around the way to deal with issues of admissibility or presentation of evidence in sexual and violent crimes. Because of course we can never, sir, legislate away the pain and suffering that is faced by victims, but we can, at the very least, Mr. Speaker, take very sound pragmatic efforts to help to make the process of the justice system and particularly the giving and hearing of evidence as easy as we possibly can for those victims. So I'd like to touch upon first the provisions around child witnesses giving evidence, particularly giving evidence in alternative ways. And also, sir, the right to a support person to be present with them when they're giving that evidence. I think this is an extraordinarily important area of the changes that are proposed in this bill. And I'm very fortunate, although I'm a father, sir, I'm very fortunate that I can say that none of my children have ever had to find themselves in a position to have to give evidence in court on any matter, one of great serious and great trauma or otherwise. So I don't pretend to be able to say that I can fully appreciate what that must be like. But I think it's well acknowledged across our society, and a very strong feeling I do get as a parent, that it must be an incredibly distressing exercise for children to go through and to be put through in a means that is necessary as part of ensuring that defence a defendant gets a fair hearing, but which must be very, very difficult for a child in a situation where they are there to give evidence. So at the moment, what this bill will do is it will allow a presumption that child witnesses can use alternative ways to give evidence, such as pre-recording of evidence in chief or delivering evidence via CCTV hookups or behind screens. And while it is fair and important to note that at the moment it is possible for child witnesses to use or to give evidence through alternative ways, that is only possible today if an application is made. And so I think that's quite concerning, actually, if we reflect on that a moment. What it does permit at the moment is a defence's legal team, or defendant's legal team, to actually present an argument as to why, or to try to prevent, the child or children in question giving evidence in a way that will be easier and more comfortable or less distressing for them. Now, ultimately, I think we probably all have confidence in the courts that the courts will make the right decision in the case of those applications. It certainly compounds more and more stress and worry for those child witnesses to have to go through that process before ultimately the court will make the right decision and allow them to deliver their evidence through the most appropriate means. So by taking away that need to apply and operating on the presumption that the child can deliver their evidence through an alternative means, we are helping, I think, sir, to ensure that what will still be a very difficult time for that witness will be that much easier for them. And I think this is a very important consideration for all members of this House, and certainly is in line with this government's objectives and actions, where we're very much around putting the victim at the heart of our justice system and making sure that their needs and considerations are dealt with also. I'd also like to touch upon, Mr. Speaker, the restrictions on video evidence, or video record evidence. So what this bill will do is restrict defence access to police videos of witness evidence in sexual and in violent cases. and in fact of child's evidence or complainant's evidence in all cases. Now, the fundamental reason for this is we want to help to ensure that the risk that the video records will be misplaced or misused will be minimised, and that's, I think, a very laudable basis for this. Now, I'd just like to make a point, sir, that this won't restrict the defence's access to the evidence. It may mean that the evidence will have to be viewed on police premises, or that they will have to apply to the court for a copy of those types of records, but it won't prevent the defence from gaining access to them. It won't prevent the defendant's right to the information and access to the evidence to help them go about their case. But I think it is another element that this bill introduces which will help to remove barriers perhaps to people, complainants bringing forward their case, help to reduce risks that the evidence they give may be misused or misplaced. And moving on from that, sir, I'd also like to touch upon, and my colleague Mr Bishop talked, I think, a great deal about this in his fine contribution to this debate. The notice about requirements for evidence of previous sexual history. So the requirement, Mr Speaker, that the defence will have to give notice before the start of a trial if they intend to use the evidence about a victim's sexual history with someone other than the defendant, I think is very, very important. We do, like the rest of society, we do peruse a lot of the media available, and we all hear, I think, cases, sir, where a complainant's past activities are brought to bear by the defence in a way that is intended to place a certain colour on their character, which might or might not bring a jury to view other evidence in another light. I think it's very important, sir, that not necessarily that we have a situation where such evidence is admissible, but that the defence can know in advance that that the complainant can know in advance that they are going to be questioned on certain matters, or certain matters might be brought to light, and that they can also prepare adequately to deal with those. One thing that springs to mind, actually, I would suggest it's possibly not a complete match to the sort of example I just used, but we do know that in the defence of Clayton Weatherston, who was ultimately found guilty of the murder of Sophie Elliott, his defence team absolutely did use the victims, in that case the murder victims, past behaviours, and in fact I think what they held were some fairly recent behaviours, to cast a light on her character, and perhaps, I think, in an attempt to mitigate the actions of Mr Weatherston. And I recall, sir, I think the public reaction to that, certainly the media reaction, was a strong sense that that was a reprehensible sort of an approach to take in that case. And so I think the measures that we're looking to put in place through this bill will give the complainants and their team a fairer playing field in that instance to actually address the sorts of issues that the defence might bring up, and in fact allow tests of admissibility earlier rather than in the middle of proceedings. So I think that's another piece that the bill will bring about, which is very, very good to see come about. Another element I'll touch upon is around privilege for plea discussions. At the moment, it does seem that perhaps there is some concern that there may not be clear privilege in respect of communication on plea discussions, but there is a view, and certainly the Law Commission, Mr Speaker, held a view and recommended reform in the area to ensure that defence and police can go through full and frank plea discussions in a means that might help to encourage early disposal of cases, which will also have an impact and a positive impact on perhaps removing witnesses from a need to testify and therefore reduce the stress that might be placed upon them. So I think this is an extremely sound, very welcome bill to be introduced to the House, Mr Speaker, and I commend it to the House.
The question is that the motion be... Oh, Paul Foster-Bell.